For motion, item number 1.
Yes,
Maybe, Your Worship, as per the last order dated 9th of September, the government advocate was directed to get instructions as to whether the post of Joint Secretary ICT has been created by the government. The petitioner was working as Chief Informatics Officer and he had been transferred to the post of Joint Secretary ICT, which has been challenged by him on the ground that there is no post of Joint Secretary ICT created by the state respondents. And apart from that, the other ground was that as per the recruitment rules, the post of Chief Informatics Officer can be filled up 100% by promotion from the post of Principal Informatics Officer.
yes, you were saying?
That, page 15, annexure 3. These are the Mizoram State Information and Commission Technology Department Group A Recruitment Rules 2012. And if I may take Lordship to page 17, the post of Chief Informatics Officer, column 11, method of recruitment, whether by direct recruitment or by promotion or by deputation/transfer, and percentage of posts to be filled by various methods. 100% promotion. Column 12, promotion from Principal Informatics Officer with 5 years regular service in the grade. So my humble submission, Your Lordship, is that this post of Chief Informatics Officer can be filled up only by 100% promotion. The question of transfer does not arise. But now, this post which I am holding, I have been transferred to the post of Joint Secretary ICT and the respondent number 4 has been posted in. But as per the rules, this post can be filled up only by promotion. And apart from that, there is no post of Joint Secretary ICT created by the respondents. So that is why I have challenged the transfer order. If Your Lordship will kindly see page 19, annexure 5. In the interest of public service, the Governor of Mizoram is pleased to order transfer of Dr. Laltha Moana, Chief Informatics Officer ICT, to the post of Joint Secretary ICT. But there is no such post of Joint Secretary ICT created by the state respondents.
So the thing is that, is it required to be created? See, post of secretary, joint secretary, additional secretary, all this. They are not created department-wise.
But if Your Lordship will see the posting order, it is Joint Secretary, ICT. So to the ICT department. And like I showed Your Lordship, the post of Chief Informatics Officer can only be filled up 100% by promotion, not by transfer.
There are two things involved, it seems. Yes. One is your transfer.
Yes.
Secondly is the posting of this respondent.
Respondent number 4.
In the post.
Page 20.
The question is, insofar as your transfer is concerned, are you not in a transferable post?
Yeah. No.
Can you claim that you should be in that post for till your retirement?
No, I am in a transferable post. If in fact, page 16 of the rules, Rule 7 clearly says that it is a transferable post.
Page 16.
These are the 2012 rules, Rule 7.
Please read.
Notwithstanding anything contained in these rules, the Governor of Mizoram, in public interest, shall have the right and power to transfer any office so recruited under these rules to any other post or position which is equivalent in rank or grade. I think it should be any officer. But well, they may have the right to transfer me, but do they have the right to fill up this post by transfer? Because as per this rules, this post of Chief Informatics Officer can be filled up only 100% by promotion.
Correct. That's why I said two
Yes.
things.
Yeah.
One is your transfer. You said it's a transfer post.
Yes.
Then the other thing is whether another person can be transferred or not.
Yes.
Whether
Column 11.
no,
Column
whether
11 of
that
the,
can be questioned by you.
Judge, because I'm holding the post.
But you've been transferred.
I've been, but Judge, to a non-existent post.
Now, how do you say it's a non-existent post? See, I think the instructions are here. There are a number of posts of joint secretary which were created without mentioning specific department. Joint secretaries of departments are not necessarily posted against specifically posts created for those departments. In fact, government can post joint secretary level officer against post of joint secretary and assign allocate department. So basically that's what they want to say. You are posted as a joint secretary and you're allocated the ICT. But you're saying that otherwise the order says
Yes.
that it's joint secretary ICT.
ICT.
That's why the concept of whether there being any created posts specifically for
That department.
ICT,
Yes.
joint secretary is there or not, or was. But I don't think it's like that. Let them file their affidavit.
Yes, sir.
We'll take up the matter once they file the affidavit. Ms. Caroline K. Dumwarpui, learned government advocate, has obtained instructions in terms of the direction of this court. She, however, submits that she may be given time to file a comprehensive counter affidavit in the matter. Considering the prayer, 3 weeks' time is granted. That's grateful.
The interim order may kindly
What is the interim order?
last paragraph, the notification has been kept in abeyance.
Which notification?
Page 20.
Serial number 2.
Yes. Respondent number 4.
No, no, why should we keep this in abeyance, Mr. Malhotra? Let him join. What is there?
Prima facie, at that stage, the court was of the view that since there is no post of Joint Secretary ICT, and since the post of Chief Informatics Officer can be filled up only by promotion, the posting of the respondent number 4. Because column 11 says that it can be only filled up by promotion, not by transfer or deputation.
The order says the stand taken by the petitioner's counsel with regard to posting of so-and-so may not have bearing in this case if post of so-and-so has been created by accordingly listed. So it was basically on the whether the post has been created or not. We'll stop the interim order, Mr. Malhotra. We'll just say subject to the outcome. The interim order passed earlier shall not continue.
Otherwise, Your Worship may kindly fix a short date, since she's already got the instructions.
This one-page instruction, I don't know.
Yeah.
It might take some time.
Otherwise, then the writ petition will become infructuous. A short date may kindly be given.
Ms. Caroline, what do you say?
At least 2 weeks' time.
Okay, we'll grant you 2 weeks' time, but you please try to file your affidavit so that we can take up the entire matter.
Yes, my lord.
Then instead of that, you write 2 weeks' time. list the matter again. Give a date
1st of October.
on 1st of October 2022.
My lord, if it can be
Yes.
fixed on 3rd of October.
Third.
Yes, my lord.
What is that date?
Thursday.
All right. List on 3rd of October 2020.
And the order
Interim
may
order
kindly-
passed earlier shall continue till that date.
I'm on that.
Orders, item number 6.
Sorry, Malak. Since it has jumped to the order column, Malak.
Who's the PP?
I think she's on VC, Miss Mary.
Where is she?
She's supposed to appear in this case.
Yes, what is the matter?
Malak, this is a bail application. Second time I've filed this bail application before your lordship. The last time your lordship has rejected our bail application on the grounds that the case is too premature at this stage.
My lord, I may, before we continue further, my
Yes.
lord.
Yes.
My lord, this matter is taken up by Miss Linda, and I do not have the brief with me. So,
Where is she, Mr.?
before my learned friend continue, if pass over for the time being, my learned friend is on legs, ma'am.
She's on legs.
No.
Where is Miss Linda? Can you hear me, Miss Mary?
She's on legs, your lordship. She's on legs.
So then we'll wait for some time.
Yeah, my lord.
Yes.
Item number 7.
May I please, your lord. This IA is an application for condonation of 226 days in filing an appeal against the impugned order 3010-2023 passed by the Lanat Additional District Judge 2 in CMA number 672 of 2023 arising out of RFA 5 of 2023.
What is that CMA?
CMA 672 is for setting aside the dismissal order passed by the Lanat Additional District Judge. My case was that I have filed an appeal which was registered as RFA 5 of 2023. Now, my appeal along with condonation application, that is CMA 160 of 2023, was dismissed on default. Now, I have approached the first appellate court by filing an application to readmit the appeal. Now that readmission of appeal was dismissed, now instead of filing an appeal against the impugned order which was passed in CMS 672, that is right, impugned order 3010-2023, I have approached this honorable court by way of second appeal, challenging the order 27-7-2023. Now I have approached this honorable court by way of first appeal from order, ma'am. And to challenge the impugned order dated 30-10-2023, there is a delay of 226 days.
672 was restoration.
Yes,
Restoration was dismissed.
was dismissed.
On what ground?
Now, the restoration was dismissed that basically it says that I have to approach the High Court under Section 100.
What was dismissed was the application for condonation of delay.
Yes,
Then accordingly, RFA also was
was
dismissed.
dismissed.
That was due to non-prosecution.
Non-prosecution.
What happened?
Dismissed on default. due to the fault of the council.
Now, if the case is dismissed for default, that was by the which court?
First Appellate Court, London Additional District Judge 2.
And your restoration application was under what provision?
No provision was mentioned when they filed the application, my
So
lord.
that's why it was dismissed.
No, that is not the sole ground. The sole ground, the main ground is that you cannot approach this court again. You have to go to the High Court challenging the dismissal order. That was,
The same court cannot restore it.
so there is a provision, my lord.
What is the provision?
Order 43, Rule 1T.
Provision is there.
Yes, provision is there. Now, instead of challenging that order which dismiss CMS 672 for readmission of appeal, I have come before your lordship, this court, challenging the first dismissal order, that is 27/7/2023. So this court has passed an order, my lord. If your lordship will see at page 23 of my application.
Yes, 23.
This is the order, my lord.
23 is the middle of the order.
Yes, I'll take your lordship just for to apprise your lordship what has transpired.
Yes,
Para 15.
yes.
In view of this court, CMA number 672/2023 is an application made under Order 41 Rule 19 CPC. Inasmuch as it can be implied that CMA number 160 of 2023 had been dismissed under Order 41 Rule 11 or Rule 17 CPC. Though the appellant had the opportunity to file a second appeal on the rejection of CMA number 160 of 2023, CMA number 160 of 2023 is dismissal of condonation application, and RFA number 5 of 2023. The appellant had availed of the provisions of Order 41 Rule 19 CPC for challenging the impugned order dated 27/7/2023. Unless the appellant makes a challenge to the impugned order dated 30/10/2023, passed in CMA number 672 of 2023, the appellant cannot make a challenge to the above orders dated 27/7/2023, passed in CMA number 160 of 2023 and RFA number 5 of 2023. As an appeal against the order of refusal under Order 19 of Rule 41 to readmit the appeal is required. Now I'll take your lordship to Para 17. In view of the provisions of the CPC, this court does not find any ground to allow the present appeal, as the challenge has to be made to the order dismissing CMA number 672 of 2023, and the same has to be made in terms of Order 43 Rule 1 GCPC. At page 24, Para 18, it is needless to add that the appellants can always avail the correct procedure provided in the CPC for challenging the above said orders if so advised. Now this,
Challenging the dismissal of your application
yes,
for restoration. And this court has said that you have to challenge the dismissal order itself.
no, first,
The
first,
first
I-
order.
First order I have challenged, that is dismissal of condonation application. I have challenged that, and the order which refused to admit the appeal, I have not challenged that. Now, this honorable court has said that there is a provision under Order 43 Rule 1T. Unless you challenge that order, you cannot challenge this 27/7/2023 order.
Where's that 27/7 order? You have not annexed it.
(40 to 42). Your Lordship will see at page 40, 42. That was the order passed in RFA number 5 of 2023. And the order passed in CMA number 160 of 2023 is at page 37 to 39. First, I'll take your Lordship to page 38, that is the dismissal of the condonation application. May I read this, my lord?
Which page?
Page 38.
This is in which?
In
Page.
CMA number 160 of 2023. That is in my condonation application.
No, CMS 160 and RFA 5 are dismissed together,
Yes.
isn't it? Separate order.
Consequent upon dismissal of 160, RFA was dismissed.
Okay. First 160 was dismissed. 160 was regarding condonation of delay.
Yes.
For default. Both were dismissed for default.
Yes.
Thereafter, what did you do? You filed,
Thereafter, I have filed for readmission of appeal, which was registered at CMS 672. Now, CMS 672 was dismissed again by order 30/10/2023.
yes.
So, it is this order that I have appealed in this FAO.
Okay. Before this FAO, you had filed one more,
RSA
one RSA.
against that CMA 160 and RFA dismissal 5 of 2023. Now, this court was of the view that wrong mentioning of provision by the learned First Appellate Court is of inconsequential manner.
You were reading paragraph 17, which is 15 and 17, page 23.
Yes, my lord. So
672.
it was all because of procedural error committed by the learned First Appellate Court in the first instance.
Who are the parties here?
Only private respondent is there,
Notice will have to go at this stage.
my lord.
Third, Mr. Silal Fakzola, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 2 to 6 days delay in filing the connected FAO number 5 of 2024. Issue notice to the sole respondent returnable by 3 weeks.
My lord.
Petitioner to take, applicant to take steps for service of notice upon the sole respondent by registered post with ADDU within 3 days. What about Dusty? Not possible.
I can do that also.
Additionally, the petitioner is, applicant is permitted to serve notice to the sole respondent by way of Dusty within 10 days. And then file an affidavit as proof of service. List the matter again after 3 weeks. The respondent would be at liberty to file objection to the application, if so advised.
Item number 6.
Ms. Dinda, you're here in this case? All right.
May I please, your lord. My lord, I'll take a lordship to the rejection order which was passed earlier. It is at page 92. That's from page 92. It's a long order, my lord.
It's a long order, and court had also analyzed your case.
It has passed.
What is new in this case?
Now, when your lordship has passed that order, if your lordship may kindly see at page 100, paragraph
There are 5 witnesses.
5 witnesses.
2 witnesses were examined that time.
No, your lordship has said that in the present case, it may be seen that trial is at very initial state.
No. See, just listen.
My lord.
There are 5 witnesses in all
Yes,
for the prosecution.
my lord.
That time, 2 witnesses were already examined. Now, what is the stage today? How many have been examined?
Now 4 have left. 4. Still, they are still yet to be examined.
How can that be? There were only 5 witnesses.
6. No, 5 witnesses. Oh yes, 5 witnesses.
So that leaves
sorry.
only 3
Only
witnesses. Then how do you say that one more is there? 4 witnesses.
There is slip of tongue, my lord. There is slip of tongue.
Okay, but do you mean to say that no witnesses have been examined since then?
Yes, my lord.
Are you sure?
There is how the trial has been conducted, my lord.
Come to page 107.
107, yes. The list of witnesses are here.
Serial number 1 and 2 have been examined.
Yes, yes.
All that remains is 3, 4, 5.
3, 4, 5.
These 3 have not been examined
No, no.
since March 2024. April, May, June, July, August, September. 6 months have come.
There is the trend, my lord. Now, if your lordship will see that your lordship has passed the order on 27/3/2024. Now, PW number 1 was examined on 21/5/2024. That is after your lordship has passed the order.
DW.
PW number 1.
Okay.
Your lordship has passed the order on 27/3/2024. PW number 1 and PW number 2 were examined on 21/5/24. That is subsequent to the passing of the order.
I see.
So there is a new development. Now, my lord, in the previous court dates, I have raised some points regarding the discrepancies in the drawing of samples, but I will not take that as a ground now because there are new developments. My lord will see that on the list of witnesses, the magistrate before whom the inventory was made was not made a prosecution witnesses. Your lordship will see in the list of witnesses that is on page 107. Because in NDPS case, judicial magistrate are one of the most vital witnesses as per section 52 as NDPS. Your lordship will see at page 58. That is the application made by the IO to the magistrate, page 58. Has your lordship got it?
Page 58.
Page 58.
What is this?
This is an application made by the investigating officer to the CJM under section 52A.
Yes.
Your lordship will see at the bottom. Now there is a signature of the judicial magistrate first class. Now we do not know who is this person who had appended its signature. It mentions judicial magistrate first class. No name has been mentioned. It simply mentions judicial magistrate first class. No 1, 2, 3, 4. Because there are around, I think, 2, 3, 4 magistrates. More than one judicial magistrate in Aizawl district. If I may bother your lordship again at page 59, 60, 61. The name of the magistrate before whom this inventory was made or any photographs taken is not mentioned. So this creates a serious doubt upon the case of the prosecution, my lord. Given the fact that this magistrate, whom we do not know, has not been cited as a prosecution witness. Now, in this particular case, the record which has been provided to me, the charge sheet, does not enclose the photographs which is mandated under section 52A. Your Lordship may kindly come to 52A of the NDPS Act. (52A) subclause 2. I'll jump to 52A subclause 2.
Yes,
May I read with your Lordship permission?
yes.
Where any narcotic drug, psychotropic substance, controlled substance, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer employed under section 53, the officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances, or conveyances in any proceedings under this act, and make an application to any magistrate for the purpose of A. Certifying the correctness of the inventory so prepared. B. Taking in the presence of such magistrate photographs of such drugs, substance, or conveyances, and certifying such photographs as true. If I may stop at this point, my lord, my submission is that these photographs of the seized drugs has not been taken, let alone in the presence of the magistrate. So that is my another point. C. Allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. Now at this stage, we do not know who is such magistrate. Such magistrate could have been ascertained when the name of the magistrate is mentioned just below her signature or his signature. Now, I'll move to the next point, Your Lordship. The evidence of PW number 1 and PW number 2. Since this is the time that Your Lordship will appreciate for the first time the evidence of PW 1 and 2. Page 160. This is the seizing officer. My lord, I'll read from the examination in chief.
Yes.
I know the accused persons. On dated 15/8/2023 at 11:30 p.m., information was received from reliable person that some unknown persons were strongly suspected of possessing contraband drugs within Dorpui area, Azol in contravention of the provisions of NDPS Act 1985. Search warrant could not be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender. I reduced the information in writing. Self with parties immediately left DSB office for Dorpui Azol to conduct search, seizure, and arrest of the suspected person as per provision of under section 42 NDPS Act 1985. On reaching Dorpui Azol, arrangement of two reliable independent witnesses were made, namely Zoram Thanga and Nal Chakim of Dorpui locality. Self with party accompanied by the aforementioned two witnesses surveyed New Market area, Dorpui, and at around 5:15 a.m., dated 16/8/2023, the two suspected male persons were located at Dorpui carrying a wooden box near P. Biaksangi residence and were apprehended immediately. I introduced myself to the suspected persons by telling my name and that I am a police officer working in DSB Azol. On asking the suspected persons introduce themselves as Saurabh Nath and MD Nur Ahmed, the two suspected persons were directed to open the said wooden box, and they took out a black color bag which inside 2 bundles wrapped with brown color paper, inside which 5 small bundles each were packed. Each small bundles contained 10 blue color sachet which further contained red color tablets suspected to be methamphetamine. The tablets were counted and altogether it was 20,000 tablets. I seized the same from the joint possession of the 2 accused persons at 7:15 a.m. dated 16/8/2023 in the presence of civilian witnesses. I also seized mobile phones Redmi 10 and Oppo A57 from the accused persons. Weighing, packing, sealing and labeling of the seized article were done at the PO in the presence of accused and witnesses. Marking of the seized article was done as Exhibit A1, which weighed 2.330 kgs. My preliminary inquiry reveals that the SA was bound for Tripura via Assam. I submitted report of seizure and arrest and FIR to OC Azol PS along with the seized article. Exhibits 1 to 7 are there. And cross-examination by Lanet DL for accused Nur Ahmed. I deny that I am not the first person who received the information while I was at DSB office. It is a fact that I did not receive the specific information with regard to transportation of methamphetamine, but I have received information that contraband article is likely to be transported. It is a fact that in the instant case, information was recorded by me and Inspector Laldonglian at DSB. It is a fact that the wooden box was retrieved from Zokotar Mexicab Sumo, but we cannot ascertain the said vehicle and the registration number as it had already left while we tried to approach the same. It is a fact that the said wooden box is not transparent. The contents therein cannot be seen from outside. It is a fact that the wooden box could not be seized, as the same was destroyed while opening. It is a fact that there is no photograph of the wooden box in which the alleged seized article was kept. It is a fact that accused Nur Ahmed could not write, read, or speak Mizo language. It is a fact that the statements of the accused were recorded by me. It is a fact that I do not know as to whether Malkhana register or godown receipt is in the charge sheet. It is a fact that even though we had seized the mobile phones of the accused persons, we had not extracted the call data records of the said accused persons. It is a fact that I am not aware of the samples drawn. It is not a fact that I am deposing falsely before the court today. Cross-examination by Lana DL for accused Saurabh Nath. It is a fact that name of the accused was not specifically mentioned in my information received. It is a fact that seizure and arrest took place at around 17:15 a.m. on the next morning. It is also a fact that my informants were not listed as witnesses in this instant case. It is a fact that I do not prepare godown Malkhana receipt, and also that I simply submitted all the essay along with the accused person to OC Azol PS. It is a fact that weighing machine used for weighing the said seized article was brought by me to the PO. I deny that the said submitted body search was conducted upon the accused. It is a fact that the color of the seized article is red color. It is a fact that I am not deposing falsely before the court. Now, Your Lordship may kindly see that NDPS Seizure, Storage, Sampling and Disposal Rules 2022. That is in the Act itself, my lord. Your Lordship will see Rule 5 of the Narcotic Drugs Psychotropic Substance Seizure, Storage, Sampling and Disposal Rules 2022. Rule 5.
Deposit and godowns.
Yes, my lord. Now, before I read this, my lord will see that on the appreciation of the evidence of this seizure witness, he doesn't know whether Malkhana register or godown receipt is in the charge sheet. On cross-examination by counsel for Nur Ahmed and on cross-examination by counsel for Saurabh Nath, he stated that he did not prepare go down Malkhana receipt at all. Now, if your lordship will see Rule 5, deposit in go downs. If I may kindly read.
Yes.
All seized materials referred to in sub-rule 1 of Rule 3 after seizure under the Act shall be deposited by the seizing officer in the nearest go down designated under Rule 4 within 48 hours from the time of seizure along with a forwarding memorandum in Form 1. Your lordship will see Form 1 after Rule 29. It's provided in the rule itself. Now this forwarding memorandum is not in the charge sheet. Go down receipt or Malkhana receipt is also not in the charge sheet. That has been acknowledged by the seizing officer itself.
You are referring to page 161, cross-examination
Yes, my lord.
by the defense lawyer for accused Noor Ahmed,
Yes.
serial number 10.
Yes, my lord. And in respect of Sauramnath, serial number 4.
Serial number 4. This is regarding the Malkhana register, go down receipt and all that in the charge
Yes,
sheet.
my lord.
He says that he doesn't know.
And he affirmed that in para number 4 that he did not prepare. And it was incumbent upon the seizing officer to prepare under Form 1 forwarding memorandum, my lord, as per the rules, narcotic drugs and psychotropic substance, seizure, storage, sampling, and disposal rules.
The charge sheet is available in the,
It's in the bail application, my lord.
where is the charge sheet? Starts from which page?
My lord, I'll come to that. Page 32. It starts from page 32, and the charge sheet itself is page 36.
36 or 108?
108 is also there, my lord,
How many charge sheets have you annexed?
because we have annexed previously in the bail application. That is why we have to annex again. I'll come to page 108, my lord. I think that is more detailed.
You had annexed 2 copies.
Yes, yes. May I read the charge sheet, my lord?
Yes.
The story of the case in brief for prosecution is that on 16/8/2023 at 9:10 a.m. a written complaint was submitted by SIT Tuam Jungnoa District Special Branch Azol District stating that on 15/8/2023 around 11:30 p.m. an information has received from some source stating that some person has been strongly suspected to committing an offense in contravention of the provision of NDPS Act 1985 at the area of Dorpui, Aizol. In this regard, information report was submitted to Intelligence Branch Inspector, District Special Branch Aizol. However, search warrant could not be obtained from the competent authority due to fear of concealment of the contraband items or escape of the offender. Then he with party immediately proceeded towards Dorpui, Aizol, and on reaching the said place, two independent witnesses, namely Zoram Thanga, son of Zamming Lena late, and Lal Chakima, son of Van Tuama, board of Dorpui locality, were arranged. So after making arrangement of two local independent witnesses, search for the suspected persons was conducted within Dorpui New Market area, and at around 5:15 a.m. of dated 16/8/2023, two suspected male persons were located at Dorpui near PBXangi residence, and they were carrying a wooden box. They were immediately apprehended. On asking, the suspected persons introduced themselves as Surabnat, son of Ardendunat of Tiltai PS so and so. They were informed that they were suspected of possessing contraband items in contravention of NPCC Act. So in the presence of witnesses, the two apprehended persons were directed to open the said wooden box, and they took out a black color bag containing two bundles wrapped with brown colored paper, inside of which 5 bundles, each small bundles contains 10 blue color sachets each, and inside of which a red colored tablet suspected to be methamphetamine were found. Counting of all the red colored tablets kept inside the said sachet were done in the presence of reliable witnesses and the two alleged accused. The suspected methamphetamines were 20,000 tablets. The same were seized from the joint position of the aforesaid two apprehended persons in the presence of witnesses mentioned above. Mobile phones Redmi 10, Oppo A57 were also seized from the apprehended persons. Weighing, packing, sealing, and labeling of the seized suspected methamphetamine were done at the spot in the presence of accused and witnesses. Marking of the suspected methamphetamine was done as Exhibit A1, which weighed 2.330 kgs, which worth 76 lakhs at international market. Hence, case was registered against the two accused persons. Aizol PS case number 558/23 dated 16/8/2023 under section 22C29 NDPS Act was duly investigated into. During the course of investigation, the following steps had been taken. The complainant SIT Thom Chungnu of District Special Branch Aizol District was carefully examined and recorded his statement, which was corroborated with the FIR submitted by him. Arrested the two accused, namely A1 MD Nur Ahmed and A2 Soram Nat. Observing all arrest formalities and kept at PS lockup after medical examination was done at Civil Hospital Aizol. 3. The two accused were carefully examined and recorded their statement. They stated that they proceeded towards Zaukotar on 7/8/2023 along with their two other companions, namely Johnny Aslam and Didar Mia, both of Silchar, Assam, from Dharmanagar, Tripura, to buy methamphetamine or heroin number 4. They reached Zaukotar on 9/8/2023 and stayed at tourist lodge. After they purchased methamphetamine from one person at Zaukotar, they made a wooden trunk and concealed the consignment under cucumbers, which they also purchased for this purpose. They left Zaukotar on 15/8/2023 and requested the person from whom they purchased the drugs to send the consignment to Aizol. In the early morning of 16/8/2023, while they were collecting the consignment from the Mexicab Sumo, police party intercepted and they were apprehended. As per the statement, they intended to sell the drugs at Silchar, Assam. The seized contraband drugs, 20,000 tablets of methamphetamine and the two mobile phones Redmi 10 and Oppo A57 are kept in PS Malkana White MR number 254 of 2023. Well, may I just stop here? The police recorded the statement of the accused persons in Mizo language. Now, if your lordship will see the deposition of PW number 1, they cannot read, write, or understand Mizo language. It has been clearly mentioned in the deposition of PW number 1. $160.
You were reading from which page?
My lord, I'll read that. I'll read that.
No, just now. The
Oh.
chart sheet.
Charge sheet is at
Which paragraph you were reading?
para 3, last two sentences. As per the statement, and at in the beginning of para 3, the two accused were carefully examined and recorded their statement.
Yes.
Now the statement were recorded in Mizo language, in Mizo vernacular. Here, in the cross-examination at para 8 of PW number 1, page 161.
No, that I noticed
Yes,
already.
yes.
No, what is wrong in asking them in whatever language they understand and recording it in the vernacular Mizo?
That was not there. It was not mentioned anywhere that they got it translated in their own known language. While they recorded the statement under sections 161. Nothing was there.
161 is recorded in Mizo vernacular.
Yes, yes. And it has been affirmed that Nur Ahmed could not write, read, or speak Mizo language. Right from the stage of investigation, my lord.
No, but they must have communicated in some other language.
Yeah, I cannot assume at this stage, my lord, but I'm only reading this evidence, my lord.
Two accused were carefully examined and recorded their statements. Statements were recorded
Statements were recorded.
in Mizo.
I agree, but it does not.
They could not speak, write, read, and write Mizo, but maybe they spoke to him in a language which he understood.
My lord,
So that's why I'm telling you, what is wrong if it is
No.
if we speak in English and I write down the judgment in Mizo?
I'll not assume at this stage, my lord.
Anyway,
Now, I think I'm at para 5 now, page 109 of the charge sheet. Submitted an application to the Honorable Court requesting certificate of correctness of inventory, permission to take photographs of the seized contrabands in the inventory and certify such photographs as true, drawing of the representative samples and certify the correctness of the list of sample drawn. Obtain certificate of correctness of the inventory from CJM Azol Judicial District. Now, we do not know who is the judicial magistrate. CJM is not a judicial magistrate. In the inventory itself, there was a seal of a judicial magistrate. The names, which we do not know. Page 58, my lord. The CJM might have endorsed his judicial magistrate, but this judicial magistrate, we do not know judicial magistrate 1, 2, or 3. We do not know the name. And this creates doubts upon the case of the prosecution, my lord. We do not have at this stage, my lord, the photographs which the IO has mentioned in para 5. So these are all clear violation of section 52A of the NDPS Act.
serial number 4 speaks about that Malkhana registration number.
No, serial number 5, my lord.
4.
Yes,
MR number 254 of 2023.
23. But that Malkhana receipt or go down receipt was nowhere to be found in the charge sheet. And the form number 1 under Rule 5 as mandated by the Narcotic Sampling, Seizure and Disposal Rules of 2022 was not there, my lord.
Yes. What else?
Now, therefore, the IO has found a prima facie case against the accused persons under section 22C 29. Now, my lord, from the evidence which had already been adduced before the court, there is no chance that the prosecution will earn their conviction and there is no incriminating materials against the accused except to the fact that they have carried the wooden box. And now, if your lordship may kindly see the evidence of PW number 2, who is the civilian seizure witness, page 163. And this civilian witness will not support the prosecution case.
Yes.
May I read, my lord?
Yes.
I know the accused persons. On dated 16/8/2023 at 7:15 a.m., the DSB staff also seized 2.330 kgs of suspected methamphetamine kept inside a wooden box from the possession of accused Soramnath and MD Nur Ahmed. Weighing, packing, and sealing of the seized article were done at the PO in my presence. I appended my signature in the seizure memo. Cross-examination by the accused. It is a fact that I cannot mention the name and ranks of the DSB staff, which I have mentioned in my examination in chief para number 2, except SI Putwama. It is a fact that when I was requested by the DSB staff to witness the arrest and seizure, the accused persons were already detained inside the restaurant of Mainul. It is a fact that the seized contraband was recovered from the wooden box, which also contains cucumbers. It is a fact that I have not seen or witnessed from where the wooden box was recovered. It is a fact that I have not seen or witnessed from where the wooden box was recovered. The seizure witness, civilian seizure witness, does not know from where the wooden box was recovered. At para 5, it is a fact that the wooden box is not transparent and therefore the contents therein cannot be seen without opening the said box. It is a fact that I do not know whether wooden box was seized by the DSB staff, but I know that they have taken the wooden box along with the cucumbers which were put inside the said wooden box. It is a fact that even though Exhibit P2B is my signature, the signature which appears in the property search and seizure form, that is receipt form, is not my signature even though it attempted to symbolize my signature. Your lordship will see this on page 49 and 50, at the receiver form. Page 49 and 50. Your lordship will see at page 50 at the bottom, witness number 2.
Page 50.
Page 50. This was what the witness number 2 had said at para 7. It is a fact that even though Exhibit P2B, it was exhibited Exhibit P2B, is my signature, the signature which appears in the property search and seizure form, that is a receipt form, it is not my signature even though it attempted to symbolize my signature.
What is P2B?
P2B is the signature.
It is not marked as P2B.
It's marked in the court record, man. In the trial court record.
Witness number 1 and witness number 2.
Mano.
So this person, PW2 is what? Witness number 1?
Witness number 2, civilian witness. He is the civilian seizure witness, Mr. Zoram Thawan.
There were 2 persons.
Yes, my lord. Another witness was not examined till, has not been examined till date. Your lordship will see at the list of witnesses at page 107.
How come the names are not given?
Yes, my lord. So his signature was apparently forged, my lord.
Zoram Thanga.
And he, in fact, affirmed this in his deposition, my lord.
Zoram Thanga is serial number 2 of
Yes.
the Caesar of the list of witnesses.
Yes, my lord.
He is witness number 1 or witness number 2?
Witness number 2. Witness number 1 is seizing officer.
No, no. In this page 50, property surgeon Caesar form.
He's in witness number 2.
How do we say that? Names are not here.
Names are not here, and in fact, my lord.
See, in the list of witnesses, he's number 2, no doubt.
Yes, yes, correct.
But there are 2 independent witnesses.
My lord.
He's one of them, and he's
No.
and he's the first one.
I'm sorry. It's in witness number 1. Yeah, lordship.
The other person is Lal Chakima.
Yes.
So his signature will appear.
No, I'm sorry. Your lordship will see at page 48. It's in witness number 1, column.
48.
Yes.
Zoram Thang. Okay, now name is here.
Yes. I'm sorry.
So name is here. How come? Okay. So these signatures are exhibited as P2B.
Yes, my lord.
But how do we know that? Unless we see the records.
My lord. If your lordship may call the records, I have no objection, my lord.
Can we call for the scan records? Scan records. And what is the instruction otherwise? Regarding-
these are all grounds.
No, regarding the examination of the other witnesses.
My lord,
Since
I
May, since May 21st, there has been no further development.
I have seek instructions on 26/7. At that time, there were only 2 witnesses. Maybe I can get some more information on that, since it's already in the month of September now.
How soon can they provide the scan records normally?
2 days. My lord, if I may kindly mention, I have been in custody as on date 398 days.
That's all because of your wooden box and the contents of that box. Nobody wants to keep you in jail for nothing. So we'll ask for the scanned copy. Please write down. This is the second time this is a single applicant, is it?
Yes.
The second time the petitioner is before this court seeking bail. The earlier bail application, being bail application number 33 of 2024, was rejected. Right order dated 27/3/2024. Stop. According to the applicant, there has been further development in the case with the examination of PW numbers 1 and 2 on 21/5/2024 out of the 5 named prosecution witnesses. The learned counsel for the applicant submits that there has been gross violation of the relevant provisions of the NDPS Act. Stop considering the submissions made. This court would like to peruse the records of the case. Stop, since trial is going on before the trial court. Registry shall requisition scanned copy of the records of the case. That is, what is the case number?
Criminal trial number 2139
Criminal trial number 2139
of 2023.
of 2023. 2139
Yes, my
of
lord.
2023 from the Court of Special Judge and the NPS Act, Aizawl. Today is Tuesday, isn't it? We'll have it again on Monday. List the matter again on 23/9/2024.
Deeply obliged.
Yes, Linda, you also try to find out what has happened.
By the status.
Item number 8.
My lord, the instant IA is for implement of new incumbent, Deputy Commissioner Aizawl, as respondent number 5 in the connected contempt case, my lord.
Any objection? Heard Mr. Tilal Zakim, a learned counsel for the applicant, who submits that by filing this application, the applicant seeks implement of
It's in the first page, my lord. Engineer Lalshet Puya.
Engineer Lalshet, Deputy Commissioner Aizawl District, Aizawl, as respondent number 5 in the contempt petition, since is the new incumbent. Stop, learned counsel submits that implement is necessary for effective compliance of the court's direction. Stop, the said prayer is not objected to by the learned counsel appearing for the opposite party. In view of above, implement of Sri so-and-so is hereby allowed. Sri so-and-so in the connected contempt petition is hereby allowed. IA stands disposed of. Then in the main you write, in view of the order passed today in IAC number 161 of 2024, Sri so-and-so is allowed to be impleaded as respondent number 5. Stop, the petitioner shall file the amended cause title in 2 sets within a period of 3 days
My
from
lord.
today. Next para, issue notice to the newly pleaded respondent number 5, returnable by 3 weeks. Petitioner to take steps for service of notice by registered post with ADDU within 3 days. Make it 4 days, within 4 days. List the matter again after 3 weeks. You put S, petitioners, okay?
My lord, I will be filing my power on behalf of the newly impleaded respondent number 5. I have not yet filed my power.
You have instructions?
Yes, I have received instructions, my lord.
Then you should have told me. Then you cancel that order, that part, issue notice. No. Just read that part. Issue notice, returnable by so-and-so. No, stop there. Petitioner to take steps, from there you cut. Returnable by 3 weeks. Next para. At this stage, Ms. Caroline K. Lungoipui, learned government advocate, submits that she has instructions to appear on behalf of the respondent number 5, and that she will be filing her power within power
I will be filing tomorrow, my lord.
within 2 days. Stop, she further prays for 3 weeks' time to file show cause reply, where is allowed. List the matter again after 3 weeks.
Deeply obliged.
You will give her a copy. You write that line also. At this stage, so and so, Kati, come on. Just read that. Prayers aloud. After that, you just add. The learned counsel for the petitioners shall furnish a copy of the contempt petition to Miss Caroline Kelumorpui. Just that.
Obliged.
For admission, item number 2.
Your Lordship,
Yes.
at this stage, I have been requested by one of the officials of NPCC to collect documents in regard to this case, as the previous counsel, who was representing them, could not hand over the required documents to them. And then they have asked me to collect such documents from this court. And then I have applied for the copy, and the registry had told me that since I'm not the engaged counsel, I cannot apply a CTC. And they have asked me to apply it through an application, submit an application. And then probably by today, I'll submit that application for obtaining such copies, because the previous counsel could not provide the copy to them, and they are in the process of engaging a counsel.
What is that copy?
Copy in the sense
What is that document?
writ petition copy, and the AIO, affidavit in opposition, filed by the other respondents.
Who was the previous counsel?
It's Borbuya. He was also contacted but could not give a reply, a response to the
You
department.
could have asked Mr. Asil Ramazawa, can we Xerox a copy? And
Yes, anyhow, just
why are you going around here and there like that?
yes, I was approached last week, and then it came to my mind that I can apply the same. But since that is the case, I've gone through the copy. So even I was talking to them, I can obtain the copy from them also. I'll take a photocopy and I'll
Now,
send it to them.
How do you intend to get a copy now? From the registry?
And since copy is with them, I will obtain it from them. It might be more easier for me to collect it from them now.
From them means?
Any of the councils
Why didn't it occur to you before?
that
Simply you're
the instruction to
taking
me
time
was
like that.
to obtain it from the registry, so it did not came up to my mind immediately.
Mr. Ramzan,
It appears they have been trying to take things the hard way.
because they know
Yes.
that they should
Lord
take
Sir,
more time.
I have one suggestion. Let them get a copy from Ms. Sankwi or from me. Within 1 or 2 days, everything will be ready, and there's no problem for us to supply them. Mr. Barbuya, though he was appearing earlier, he said that he will not be able to appear because of certain things. Then he had made his submission before the Honorable Court, and that was also recorded. And thereafter, Lordship, this respondent number 5 have been making repeated absence. And
Now they're appearing, so we'll post it. By which time can you prepare?
within a week, Your Lordship, if the matter is fixed.
Maybe 2 weeks at least.
Why?
Because, my lord, I have to supply the document, and then they will have to make the
That is your headache. It is
yes,
not our headache.
yes. At least 2 weeks time may be granted.
See, we have been very lenient
Yes, yes,
in granting you time
Yes.
again and again.
yes,
Don't take advantage of that.
yes, yes.
So now that we have given you the idea of getting a copy of whatever you require from either councils, you take that,
Yes, yes. I'll
And,
obtain it from them, and I'll supply it
get back to
them,
the
and
court after you are properly instructed.
then- Yes,
2 weeks is a long time. We can't grant you that much time. You will be appearing for the respondent number 5? Ultimately.
my instruction is very limited to the extent that I was asked to collect the documents, and then probably they will engage counsel who they have been engaging time and again, probably from from Guwahati. So in that way, I will have to hand it over to them, and then they will engage the counsel from Guwahati.
That is your explanation, but we are not bound by your
Yes,
arrangement.
yes, yes.
See, on many occasions, the matter has been adjourned for absence of respondent number 5. If you see the last court's order, court says that if nobody appears on that date, it will be decided on the basis of materials available on record. So if you go by this order, we have to proceed today. But since you have appeared and say that because of this difficulty, we'll grant you time, but not that long. There was the order dated 22/8/2024 as well as the order dated 26/8/2024, in which the absence of the counsel for representing respondent number 5 was recorded. Respondent number 5 is the, what is that? National Project
Private Limited.
National Project Construction Corporation Limited, bracket NPCC. Stop. Today, Mr. Roshan Subedi, learned counsel, submits that the respondent number 5 intends to engage a new counsel, and for which they require to reconstruct the case brief. Stop. For this purpose, he prays for 2 weeks' time on behalf of respondent number 5. Stop. On the other hand, Mr. Silal Ramzawal, on its senior counsel, appearing for the petitioners, expresses urgency in the matter. Next paragraph. Considering the above submissions, when shall we have it? Mr. Ramzan?
27, the lot, sir.
27.
Yes.
I'll try to.
Let the matter be listed again on 27th of September. Stop. Having regard to what has already been observed by this court on 26/8/2024, the respondent number 5 is expected to be ready for argument on that day, so that an attempt can be made to finally dispose of the case.
No plans.
I would like to.
Item number 3.
Right, please, Your Worship. This
Yes.
matter was supposed to be listed on the 13th.
13.
1-3. It was supposed to be listed on the 13th,
Then
but it's been listed today only. So this matter may come up on the, I think, on
4/11.
4/11, 4th of November.
why do you want the adjournment?
As per the last order, it was supposed to be listed on the 4th, on the 13th. and
13th of?
13th of
This month.
this month.
Okay. So,
but it was not listed on the 13th. It's been listed today. And the counsel for the respondent is one senior advocate, Mr.
Oh,
Pradeep
okay.
Sen Dekar. He's
I
from,
thought both of you are here, you're ready to argue.
yeah, he's being
No,
led
I'm
by the
being led
senior
by-
advocate.
Mr. Pradeep Sendekar, man. They are from outstation.
Counsel for the party submit that matter was supposed to be listed on 13th of September 2024, but the same has been listed only today. They submit that since the counsel for the respondent is an outstation lawyer, the matter may be listed again on
4th of
4/11.
November.
4th of November 2024. Next, but in view of the above prayer, list the matter again on 4th of November 2024.
Obliged.
Onwards.
Item number 4.
Yes,
Lordship, I'm appearing for the state respondents, and this item is fixed for hearing, admission hearing. But Lordship, I have some personal difficulty today. So if this matter can be taken up some other day, maybe next week.
so
Monday?
I think she's
Not
babysitting.
Monday.
When?
When?
Tuesday or Wednesday, Lordship. Not Monday.
Ms. Nalmal Swami, learned government advocate, submits that she has some personal difficulties to take up the matter today, and therefore prays that the matter be taken up again on Tuesday.
Yeah, 24th. Yeah.
Deeply obliged.
On 24th September 2024. In here, Papa. List again on 24.
Obliged.
Item number 5.
My lord, I'm receiving written instruction this week, my lord. As permitted in the last court date, I was given 2 weeks' time to take instruction from my client, my lord, MZU. And I was told that they are sending written instruction this week. So the matter may be listed next week or after a week.
Instruction regarding?
Regarding the reply, my lord. The reply filed by the petitioner, my lord. Reply to my affidavit in opposition.
You want to file additional affidavit in opposition? What?
Depending upon the depending upon the contents of the instruction given to me, which I'm receiving this week, my lord.
Normally, writ petition filed,
My lord.
counter affidavit filed,
My lord.
rejoinder filed.
Right, my
But
lord.
normally matter ends there.
Right, my lord.
Unless in exceptional case
Right,
where
right.
you say that some new facts have been pleaded in the what do you call
Rejoinder.
rejoinder.
Rejoinder, my lord. I don't understand that. Since they are giving me the written instruction,
So when do you want it?
let it be next, sometime in the coming week.
Parties are represented by their respective councils. And Mr. L.H. Liamshima, learned senior counsel and standing counsel MZU, submits that he may be granted a week's time.
My lord.
Since he's expecting some instructions on the affidavit in reply filed by the petitioner. In view of above, list the matter again.
26, my lord.
When?
26.
On 26th
26th.
of September 2024, as paid for.
All right.
For hearing, item numbers 9 and 10.
Lordship,
You ready?
yes, Your Lordship.
What is the matter regarding?
Your Honor, the grievance of the petitioners is that they have been appointed on contract basis in different capacities for a number of years. In item number 9, the first petitioner was appointed in 2000.
Who are they, these petitioners?
The petitioners are all working on contract basis under the respondent number 4 in different capacities.
Respondent number 4 is?
The director Rippons.
See, item 9 and 10 are clubbed together.
Yes,
Item 10, I see Havildar Lal Zwala.
yes.
What has he got to do with Ripans?
He's retired, Your Honor. Re-engaged after retirement.
Okay, re-engaged in
After
Ripans.
retirement, yes.
Security or something?
Yes.
Okay.
So, Your Honor, if your Lordship will see, there are altogether 19 petitioners in WPC 120 of 2021.
Correct.
And the first petitioner number 1 was appointed in the year 2000. And petitioner number 19 was appointed on 2nd of July 2010. And by the time this writ petition was filed, they had already worked for 10 years plus on contract basis, even the petitioner number 19. And the only difference between item 9 and item 10 is that in item 9, the petitioners herein were appointed on, engaged on contract basis without any recommendation of the selection committee.
In item 9.
In item 9. In item 10, all the petitioners were appointed or engaged on contract basis on the recommendation of the selection committee.
Okay.
And if I may take your Lordship to page 39, annexure 10.
Page 39,
Yes, annexure 20.
20.
If I may read this,
Yes.
this is from the respondent number 2 to the respondent number 4. Subject terms and condition of appointment of contractual manpower / execution of deed agreement. I am directed to refer to your letter number so and so dated 27 December 2019 on the subject mentioned above, and to say that it has been observed from the deed of agreement signed by the Rippons with the contractual manpower that they have been allowed earned leave of 30 days in a year, besides 20 days of half-pay leave and 8 days casual leave in a year. The above leave is being credited in advance on 1st January and 1st July every year. The contractual manpower has also been allowed the facility of encashment of earned leave on completion / termination of their contract. The contractual manpower in Rippons has been recruited without approval of the ministry. Besides, the terms and conditions relating to entitlement of leave to them is in violation of general guidelines. Director Rippons may please explain under which rules / guidelines the above facilities have been extended to the contractual manpower. No further extension to the existing contractual manpower should be allowed without approval of the ministry and revision of terms and conditions of their engagement. In reply, if your Lordship will kindly go to page 40, the respondent number 4 had explained how the respondents had, the petitioners had been engaged on contract basis. If I may read from page 40.
Yes.
With reference to your email on the subject cited above, I have the honor to draw your kind attention on RIPPANS, that it was established to train and educate students from Northeast in paramedical technology along with nursing and pharmacy of the 8 sister states, viz. Assam, Arunachal Pradesh, Manipur, Mizoram, Meghalaya, Nagaland, Tripura, and Sikkim. RIPPANS was established in the year 1996, realizing the need for the development of paramedical technically trained personnel and profession in the country, especially in Northeastern region. The NEC conceived the idea of establishing paramedical and allied institute in one of the northeastern states. To start with, in 1996, the institute was functioning as a regional paramedical and nursing training institute, practically minimal in rented accommodation near Civil Hospital Aizawl. In spite of the circumstances faced above, the institute conducted the following courses right from its inception: BSc Nursing, Diploma in Laboratory Technology, Certificate Course in Laboratory Technology, Diploma in X-ray Technology, Diploma in Pharmacy, Diploma in ECG, Diploma in Ophthalmic Assistant, Multi-Purpose Health Worker Course. From the year 2004 onward, all the certificate courses and diploma courses running in the institute have been upgraded to degree/postgraduate degree courses. As such, the strength of students has also grown from 183 in the year 1996 to 712 in the year 2017-18, approximately 4 times increase. It may please be mentioned that various courses run by the institute are under the regulatory bodies such as Indian Nursing Council, Pharmacy Council of India, and AICTE, who demand minimum engagement of teaching faculty for the continuing recognition of the courses. It is for the impulsion and to meet the increased workload of running the upgraded degree, PG degree courses, the additional faculty and other administrative technical manpower has been engaged on contract basis. As there is no additional post sanctioned except 85 posts which was sanctioned at the time of establishment of RIPPANS in 1995-1996. The present engagement of these 91 individuals expires on 30th of June 2020. It is therefore requested that the ministry may kindly make considerate and lenient view to the present situation of the institute as stated above, and to kindly consider the extension of contract manpower for the smooth running of the institute. So, Your Worship, as per the explanation given by the respondent number 4, the petitioners were engaged on contract basis to meet the increased workload, because from a diploma institute, it was upgraded to a degree postgraduate degree institute, and because of the guidelines laid down by the regulatory bodies such as Indian Nursing Council, Pharmacy Council of India, and AICTE regarding minimum engagement of teaching faculty, so they had to engage for more staff for the institute due to the increased workload. That is why the petitioners were engaged.
He'll just come back in similar.
Yes, Your Honor.
Yes, Mr. Owner.
Yes. So, Your Worship, the respondent number 4, by the letter dated 15th of April 2020, page 40, had requested the respondent number 1 to 3 to consider extension of the contract manpower for smooth running of the institute, which is at page 41, last paragraph.
39 had asked for some clarification regarding how they have given their leave and all that.
Yes.
That has not been explained. Only that he requests further extension. There are, how many posts are there? 85 posts.
Yes.
Strength of the students have grown.
85 posts were created in the year 95-96 at the time of establishment of RIPANs. Subsequently, 27 posts have also been sanctioned.
27.
27. Subsequently have been,
So 85 plus 27.
yes, yes.
That is also not sufficient.
That is also not. Then, Your Worship, at page 42, this is again from the respondents number 1 to 3 to the respondent number 4. Subject extension of services of contractual manpower in RIPANs, ISOL, regarding. I am directed to refer to RIPAN's letter number so-and-so dated 14 August 2020, the above mentioned subject, and to convey the approval of the competent authority for extension of contract of existing 91 contractual manpower up to 31st December 2020, subject to the following conditions. No early HPL medical reimbursement, leave encashment should be granted to the contractual manpower. Tenure of contract period should not exceed more than 5 years as per OM dated 16 July 2019 of Ministry of Health and Family Welfare. Those who have completed more than 5 years, their services may be discontinued with 1 month's notice. It may be ensured that hiring of contractual manpower through GEM, the government e-market, should be processed before expiry of the extended period. It is also advised that such type of irregularity may not be occurred in future. So they had granted extension up to 31st December 2020.
Any further extension beyond this?
Then the page 43, annexure 23, the respondent number 4 had issued the impugned order that the contract period was extended up to 31st December 2020, subject to the following conditions, which were given in the earlier letter dated 8th of October 2020. And after this, if I may take a lordship to page 46.
Yes.
The respondents number 1 to 3 had extended the contractual period of 36 faculty members, that is 17 assistant professors and 19 demonstrators, up to 30th of April 2021. So that was the only change. The rest was only up to 31st December 2020.
So this was in respect of 36 contractual faculty.
Yeah, faculty members.
Petitioners are not included here?
We are included, Your Worship. Some are faculty members also.
I see. So this was only up till 30th of
April 2020.
April 2021. Thereafter, what happened?
Thereafter, Your Worship, at page 47, the petitioners were informed by the respondent number 4 that their contractual engagement will not be extended beyond 31st December 2020. So being aggrieved, Your Worship, the petitioners had approached this honorable court and a stay was granted by this honorable court and the petitioners are still working till date. And regarding the allegations that the contractual manpower has been recruited without approval of the ministry, if I may take Your Lordship to Annexure 28, page 52. Your Lordship will see this is the extract of the 11th Executive Council meeting of Rippons, which was earlier known as RP and NTI, dated 26th April 2001. Roman 9, contract appointment in the institute. It was approved by the Executive Council meeting. Again, page 53,
What is this meeting
Executive Council meeting.
of?
Rippons.
But it says KP and NTI is all.
Your Worship, it was earlier known as Regional Paramedical and Nursing Training Institute,
Okay, RP,
RP and NTI,
NTI.
Regional Paramedical and Nursing Training Institute. The name was subsequently changed.
Executive Council, which is chaired by whom?
The Secretary, Ministry of Health, Your Worship, the chairman. Altogether, there are 10 members to the Executive Council.
Who are they?
Uh,
It includes the,
The Secretary, Ministry of Health and Family Welfare is the chairman. Memorandum of Association.
director is the member secretary.
The chairman.
Secretary Health is the chairman,
Chairman.
and
Director General of Health Services, Government of India is his member. Altogether, there are 10 members. The respondent number 4, Director Rippons is the member secretary.
that's right. So this was a meeting held in 2001.
2001.
But who are the contract appointees?
So, Your Lordship, if Your Lordship will kindly go to page 39.
Does it cover the case of all the petitioners? Page 39.
9. Para 2. The contractual manpower in the Rippons has been recruited without the approval of the ministry. This is a wrong statement because the Executive Council meeting held on 26th April 2001 had already approved contract appointment in the institute.
No, another thing is, meeting may have approved it, but has it been conveyed?
And all along, Your Worship, the Executive Council, the chairman itself is the Secretary, Ministry of Health.
What I was saying is that the council may have approved it, but has it been put in the form of a order, notification?
Not your, but if Your Lordship will kindly
Perhaps
see,
that's why they're saying it was not approved.
Your Lordship will see page 53. If Your Lordship will see page 53. Even this is a letter dated December 30th, 2005. Again from respondent 1 to 3 to the respondent number 4. Subject, engagement of faculty members and demonstrators, etc. for BSc MLT course on contract basis. This has reference to your letter number dated 29 July 2005 on the above mentioned subject. In this connection, I am directed to convey approval of the competent authority for engagement of faculties and demonstrators as indicated below. So all along, it has been known to the ministry. Respond that their staff being engaged on contractual basis. They have been giving sanction.
So this engagement of the 7 persons,
Yes,
not 7 persons, the various 7 posts,
7 posts,
is initially for the period of 6 months.
6 months.
This was in 2005.
Yes.
Then what happens after 6 months? It's continued, extended.
It's been extended from time to time. Your Lordship will see page 54 also. This is again subject enrollment of contractual employees of RIPANS under Employees Provident Fund scheme regarding. So I am directed to refer to your letter number so-and-so dated 9th July 2013 on the subject mentioned above, and to say that the matter has been examined in consultation with IFD of this ministry and Ministry of Labour and Employment. A copy of the comments received from Ministry of Labour and Employment, white OM dated is enclosed herewith for information, taking necessary action again. So even regarding EPF, enrollment of contractual employees, page 55. Your Lordship will kindly page 55.
Yes.
As approved by the Ministry of Health and Family Welfare, white letter number dated 5th June 2014, that is at page 54, enrollment of contract employees of RIPANS under the EPF and MP Act 1952 will be done as per office memorandum issued by the Ministry of Labour and Employment, dated 19th of May 2014, and clarification received from the EPF organization, white letter number dated 2/7/2014. Again at page 56. This is regarding revision of monthly remuneration of contractual manpower regarding. I am directed to refer to RIPANS ISOL letter number dated 12th December 2017 on the subject mentioned above, and to convey approval of the competent authority for revision of the remuneration of contractual manpower in RIPANS corresponding with the 7th Central Pay Commission. It is also observed that contractual manpower engaged has been continued for the last number of years, and this may lead to invite undue litigation regarding regularization of incumbent, similar to number of cases being faced by the government. Hence, RIPANS is advised to adhere to JFR 2017, Manual of Procurement of Consultancy and Other Services 2017, particularly para 7.2 and chapter 9 thereof, for consultancy services and non-consultancy services respectively in engaging manpower on contractual basis. So all along, Your Worship, they have been aware that the petitioners have been engaged on contractual basis, and they've also been paid remuneration in accordance with the 7th Pay Commission.
So what is your prayer?
Now, the main prayer of the petitioners is that since we have been engaged on contract basis for so many years, we should be regularized in the post.
Regularize where?
I understand, Your Worship, that
There's no post.
I understand, Your Worship, but then, Your Worship, the law settled by Pyara Singh's case, ad hoc employees cannot be replaced by another set of ad hoc employees. Here, they have directed the respondent number 4 to engage contractual manpower through GEM. GEM, they call it GEM. That is Government E-Market. But
Page
that,
42. Page
yes,
42.
yes. That again is, again, engagement on contractual basis. Page 42, the second last paragraph. It may be ensured that hiring of contractual manpower through GEM should be processed. So it's like replacing the petitioners by another set of contractual employees, but engaged through GEM.
What was that Pyara Singh's judgment?
Pyara Singh's judgment is 1992, Volume 4, SCC 118. Para 46. Page 152. I'll read from para 44.
Yes.
Before parting with this case, we think it appropriate to say a few words concerning the issue of regularization of ad hoc/temporary employees in government service. The normal rule, of course, is regular recruitment through the prescribed agency, but exigencies of administration may sometimes call for an ad hoc or temporary appointment to be made. In such a situation, effort should always be to replace such an ad hoc/temporary employee by a regularly selected employee as early as possible. Such a temporary employee may also compete along with others for such regular selection/appointment. If he gets selected, well and good. But if he does not, he must give way to regularly selected candidate. The appointment of the regularly selected candidate cannot be withheld or kept in abeyance for the sake of such an ad hoc/temporary employee. Secondly, an ad hoc or temporary employee should not be replaced by another ad hoc or temporary employee. He must be replaced only by a regularly selected employee. This is necessary to avoid arbitrary action on the part of the appointing authority. So, till date, they have not created enough sanction posts to appoint regularly selected candidates.
You said that the petitioners in item 9,
Yes,
their appointment was without recommendation.
yes,
Item 10, it was with recommendation.
with recommendation.
How is that? With recommendation means
The selection committee,
SAT.
yes, advertisements were issued, there was proper selection, and there was, on the basis of selection, they were appointed on contract basis.
For a specific period of time,
Yes,
which
Then
was thereafter
it was
extended.
extended from time to time. And the best part is, although they have stated that the appointments should be made through government e-market, but recently they have issued this government notice. Your Lordship will kindly see this employment notice is number 3 of 2024-2025 dated 13th of August 2024. Applications are invited in prescribed form by the Director Rippons from Indian citizens for the following posts on contractual basis. On one hand, they are saying that the petitioner's contractual engagement should not be extended, and a contractual engagement should be done through GEM. But on the other hand, they're issuing this employment notice for engagement of different posts to be filled up on contract basis. So, I mean, your my humble submission is that they cannot blow hot and cold.
What would be the procedure in the GEM?
GEM, Your Worship, that I'm still not very sure, but I think it's like outsourcing.
Outsourcing in the sense the recruitment. Recruitment will be done by some agency.
Yes, government agency. Your Honor.
So this employment notice is not through GEM.
Not through
This is
GEM.
not GEM.
Not GEM.
Now, what happens in GEM otherwise?
Here, I think my learned friend can explain the procedure.
Okay.
Your Lordship, there is a manual for procurement of consultancy and other services 2017. There is the compilation, the other one, Your Lordship.
GFR?
Not GFR,
Oh,
the
manual.
other one, Your Lordship.
Yes.
And 9.7, there is the first page.
Yes.
It says that one-stop government e-marketplace, GEM, by DGNS and D. I'll skip this part, Your Lordship. The next page, 9.75.
Yes.
It says that authority of procurement through GEM. Procurement through GEM has been authorized as per GFR 2017 Rule 149. And it is quoted over here, my lord. Rule 149 is quoted. GEM, a government e-marketplace GEM, DGS and D or any other agency authorized by the government will host an online government e-marketplace GEM for common use goods and services. DGS and D will ensure adequate publicity, including periodic advertisement of the items to be procured through GEM for the prospective suppliers. The procurement of goods and services by ministries of departments will be mandatory for goods and services available on GEM. The credentials of suppliers on GEM shall be certified by DGS and D. The procuring authorities will certify the reasonability of rates. The GEM portal shall be utilized by the government buyers for direct online purchases as under. So the amount is given here, Your Lordship. And what had been stated by the respondents 1 to 3, that there is the ministry, they say that it is in violation of 149 of the GFR 2017, that engagement of the contractual employees, it has to be done through GEM only. That is their contention. Due to that reason only, Your Lordship, the request to extend their engagement had also been denied. Letter was sent by the refunds director.
Then what do you say about this employment notice?
It has been produced by the Land Council today only, Your Lordship. I have seen it this morning only. So if further instruction is required, then I can obtain it, Your Lordship. I have no idea about this, to be honest.
If you say that henceforth all the employment should be done through GEM,
Yes,
and at the same time you go for employment notice like this,
yes. I think I need
there
clarification
is
from
some
the.
contradiction.
Yes, if I'm allowed to take clarification.
No, but this GEM thing I still have not understood. Rule 149, you say. Procurement of goods and services by ministries or department will be mandatory. GEM portal shall be utilized by the government buyers for direct online purchases as follows. This is regarding goods. What about services?
The affidavit speaks about this 149 and rule 199 to 206 of the GFR, my lord. 199 to 206.
GFR rules.
Yes, GFR, your lordship. I think 204. $199 is identification of likely contractors. It appears that it relates to the tenders, my lord.
Here we're concerned with hiring services.
This has been referred to and quoted by the ministry, my lord,
No,
in their
I
affidavit.
just wanted to know what is the process under GEM to appoint employees on contract basis.
This is a bit confusing actually.
Yes, these particular provisions actually do not refer to the contractual employment, my lord.
You should get some person who's expert about this GEM thing. If you insist on GEM, we should be made to understand what is this
Yes.
GEM and how you should recruit.
Yes, correct, my lord. My lord, if I may kindly be given further time to obtain instruction with regard to that documents produced by the Learned Counsel for the petitioner.
Surely.
And regarding GEM also,
But overall, what is your stand in this case?
our stand is that due to the exigencies, your lordship, we need the service of these contractual employees. Then we have been engaging them by extending the period, which was to be only for 6 months only. It had been extended from time to time, and thereafter, my lord, we also requested the ministry by giving writing a letter, but that was rejected by the ministry, saying that it has to be extended only till 2020, and thereafter it has to be done only through GEM. So that is the problem. Then on the basis of the ministry's direction, then we have to terminate the employees' engagement. Refunds need their services that had been informed directly to the ministry also, my lord. But it was the direction from the ministry that they have to be terminated. Because for their engagement, no prior approval of the ministry was taken.
How do you say that when you have the meeting minutes which approves the contractual appointment as shown by Mr. Malhotra.
Their extension, Your Lordship, there is no approval for that. Extension from time to time. And it is the bylaws says that only for not exceeding 6 months, my lord. But in spite of that, their engagement had been extended from time to time. And eventually the ministry said that, no, it has to be done through GEM only. They could not be, their service engagement could not be extended.
If the engagement is only for a period of 6 months, why don't you specify that at the first instance, that your appointment is only for 6 months? And there's no question of your extension.
It appears that due to this, since bylaws had already specified that maybe it wasn't written in the agreement, Your Lordship.
So you obtain instructions then?
My lord. I'll obtain instruction, my lord, regarding GEM as well as the documents newly produced.
Employment notice.
Yes.
Please write down, by filing these two writ petitions, the contractual employees of refunds are before this court. Challenging the decision of the respondent authorities concerned to terminate their contractual employment after 31/12/2020. And the further decision to hire contractual manpower through GEM. Full form is Government E-Market, is it?
Yes, my lord. Government e-marketing.
Government E-Market. Next para, Mr. A.R. Malhotra, Learned Counsel for the petitioner, submits that despite taking such a decision, the respondent authorities are still floating advertisement, floating employment notice as recent as 13/8/2024. And thereby, contradicting their stand that hiring of contractual manpower should be done only through GEM. So Mr. Bilal Ravenga, Learned Counsel appearing for the refunds, submits that he may be given some time to obtain instructions in this regard. As paid for how much?
2 weeks time, my lord.
Learned Counsel is granted 3 weeks time to obtain instructions as to how employment notices have been floated despite the stand that the same should be done through GEM. The Learned Counsel shall also obtain instructions as to how contractual employees are sought to be engaged by applying by the through GEM. Full stop. In other words, the process involved and the modalities provided by the said method. How many sanction posts are there as of today? 85 was there in 1990. In which year was that? 1995? 96?
Your Lordship will kindly go to page 50. Page 50.
Page 50.
At page 48, the Honorable Member of Parliament Lok Sabha had written to the Health Minister, to the Health Secretary, sorry, to the Health Minister, and the replies at page 50, page 51, last paragraph. "27 additional posts have been created."
It's 2018.
2018. In the beginning, 95, 96, there were about 85 posts. So 85 plus 27.
Next para, the Learned Counsel shall also obtain instructions as to how many sanction posts are available under rebands as on today, and as to how many contractual employees have been engaged, including the petitioners. List the matter again after 3 weeks
After 3 weeks, ma'am.
on a date to be fixed by the registry.
Much obliged.
Yes, give it back.
Item number 11.
Item 12, Judge.
Yes, please write down. The prayer of Mr. A.R. Malhotra, learned counsel for the appellant and not objected to by the other side. List the matter again.
Page number 18. Page number 18 is deposition of the informant, the respondent number 1 herein.
There's one more item, my lord.
We'll
Item
have
number
this some other day,
No
Yes, my
problem,
lord.
my lord.
uh,
No problem.
instead of leaving it
Yes.
as a part hard or something like that.
Yes, and I think the case might take some time.
It will
First
take
appeal
some
after
time.
all.
First appeal after all.
What is the issue involved otherwise?
It's basically an eviction of the present appellant from his property by the respondent, who was the plaintiff. The limited grounds of appeal is that number one is that according to us, the plaintiff did not prove her case as she did not adduce any evidence on the documents that was presented to the court, number one. And number two is that the judgment and order was passed on the basis of a spot verification conducted by the Revenue Department under the direction of the Senior Civil Judge Court. However, on the date of the spot verification, the present appellant, who was the respondent, was not available, and it was clearly remarked that his unavailability was due to his COVID-19 contraction. So number one, he was not given an opportunity of being heard during the spot verification, and despite that, the spot verification report was relied on for passing the judgment and order. However, the author of that spot verification was also not produced as a witness, as in I did not get the opportunity to cross-examine also.
Okay, otherwise, how many witnesses are there?
Only three.
3
Yeah.
for the
For the
appellant.
plaintiff, for the
plaintiff?
plaintiff herself plus two witness, and the defendant adduced only himself as did not produce.
You are for the
I'm for the appellant defendant,
you are the defendant.
my lord.
You are the plaintiff.
So that is that limited ground only.
And the other issue will be, yeah, my lord, the inspection conducted by the court itself. That issue also needs to be looked into, I think.
Okay, we'll hear the parties. When can we have it? When do you want it?
I'll leave it to my learned friend. I believe he has some.
Yes, my lord, I have fixed matters tomorrow in court
Tomorrow,
number
as it
2.
is, we'll have TB.
Yes.
Tomorrow's Wednesday, isn't it?
Tomorrow is
Yes.
Wednesday.
Whether it may come up this coming Monday, my lord.
Unless you see, unless there's some emergency, we go for TV only. But if there's some sort of, like very, very urgent matters,
Yes.
parties can always, like take permission.
Yes.
Otherwise, we'll go for TV only tomorrow.
If your lordship,
This coming Monday, if my learned friend has no problem, my lord.
Friday, no, no. Friday. Will it be possible to have it on Friday, your lordship? I know it's.
Item 11. What should I clean up with the because it's all the one with the or the other tape on the time.